address the parties.
George, is your client joining?
Supposed to be.
Okay.
I can only hope at times.
Okay,
I call him to make sure.
we are live streaming. Let's see, I've got another to let in. In my haste to get rid of that last case, I closed the meeting. I shouldn't have. I should have just removed those folks. I think I wanted to get rid of all of them in one fell swoop.
So it's just Mr. Lovinger and I on the TV right now?
Dan Drake's and his daughter Mallory are also.
Okay.
If you, George, if you change your view from speaker view to gallery view, you'll be able to see everybody.
Ah, okay. Don, we're back in court. Are you online? Oh, well, let me ask the judge that right now. Judge, I have Mr. Burrows online. He was waiting. He thought you may call him back like you did the other one to get him back on. Would you like that or on Zoom?
If he wants to be able to watch everything else, or if we need to refer to a diagram, I mean, it's up to him. I will definitely establish a telephone link so that they can hear. So,
Don, do you
Let's
want
see
to be
what
able to see, or do you want the judge to call you so you can hear? So it's, okay, I'm going to have the judge call you then, Don, okay? All right, take care.
so is his the 879 number or the 250 number?
It's the 879-3366, Judge.
All right, I had two numbers written down and couldn't remember which was which.
Hello, this is Don.
Okay, Mr. Burrows, this is Judge LaFlamme. We've got us in the courtroom. Sounds like you can hear pretty well.
I can.
Okay.
Headset on this time.
Oh, good. Mr. Lovinger, you may call your first witness.
Okay, thank you, Your Honor. We would have you place Dan Drake under oath.
Mr. Drake, would you raise your right hand, please?
Yes.
You do swear to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes,
State your full name for the record.
Dan Ray Drake,
Go ahead, Mr. Lovinger.
Mr. Drake, what is your address in Michigan?
it's 12961 Pulaski Road, Jonesville, Michigan.
That is located in Jackson County, correct?
Correct.
You and your wife, Cynthia, own together some significant property that's used for farming that surrounds property that you sold to Mr. Burrows back in 1985. Is that correct?
Correct.
There's an additional named defendant in this matter, Drakeland Farms LLC. Is it correct that that's a farming business operation?
Yes, it is.
And that LLC leases the farm ground from you and your wife, correct?
Correct.
Your daughter and son are the owners of the LLC, correct?
That's correct.
You've heard the testimony from this morning and you're familiar with the basic background. The property that Mr. Burrows now lives in, you sold to him in 1985, correct?
Correct.
You lived there for how long prior to selling it to Mr. Burrows?
I purchased the property in, I believe it was November of 75. So we lived there almost 10 years.
Okay, so approximately 10 years.
Yeah.
Who did you purchase the property from?
It was Ed and Edith Fuller. They were a couple that built a home, decided that they no longer wanted to live there.
That particular property at the time you purchased it in 1975 was surrounded by farm property owned by some people named Barnhart. Is that correct?
That's correct.
Did there come, and at that time in 1975, you or a farm business that you were affiliated with were not yet cultivating that surrounding property, correct?
Correct.
Approximately when did Drakeland Farms, or whatever it was known as back then, begin to cultivate that surrounding property?
As I recall, it was probably early to mid 80s.
Okay. But sometime prior to 1985, when you sold the property to Mr. Burrows?
Yes.
Okay. When you purchased the property from your predecessors, the Barnharts continued to farm the surrounding property until you began to farm it, or did you lease it shortly after you bought the Burrows property?
No, the Barnharts probably farmed it until the early to mid 80s.
Okay. And then you leased it for a
And then
period?
our partnership leased it from them.
In 1990, you and your wife purchased that surrounding farm property, correct?
Correct.
At the time that you took ownership of the property that's now owned by Mr. Burrows, was there a fence line or a fence road that went along the eastern boundary of that property?
Yes, there was.
Okay. Approximately where was it located? You're familiar with the two surveys that the court has seen, one prepared by Ladzinski at your direction and the other prepared by Wolverine. Where did this fence line run?
The fence line ran along the east side of the driveway that was there when I purchased the property.
All right. Now I'm going to attempt to show you a picture. I may not be successful in posting it to the Zoom. I had it emailed to the judge. It's something that we were made aware of today. So let me see if I can figure out how to share my screen. There it is. Okay. Can you see the picture on your computer screen, Mr. Drake?
Yes, I can.
Your Honor and George, can you both see it?
Yes, sir.
Okay.
Yes.
Okay. Will you just, this is a photograph that was provided to me by your son today. And based on the information in the photograph, this appears to be an aerial photograph of the now Burrows property that was taken in approximately 1983. You've seen this picture before, Mr. Drake?
Not until today.
Okay. Would you agree that that is the property that you sold to Mr. Burrows, or appears to be?
Yes.
Okay. As we look at this photograph, we see the house and we see the surrounding farm fields, and there's a fairly significant sized tree up in the northeast corner. Is that the same tree that's depicted on the Wolverine survey north of the surveyed boundary line within what's called the occupied area?
Okay, I believe the tree that's showing there in front is one that blew over at a later date. But there are trees behind that one that are still there.
Okay, so that cluster, what's there now, well, let me ask you this. When you sold the property, Mr. Burrows, were all those trees probably there?
Yes.
Okay, and you say one of the trees blew down?
I believe the one that's probably shading the building that's there,
Okay,
that's where one of the sheds is located also.
okay. Do you know who cleaned up the debris from that tree?
The tree that blew down,
Yes.
No, I don't.
Okay, you didn't?
Uh, Not that I recall.
Okay. Now, this fence line, as we look at this picture, we see that there's a driveway that appears to be narrower on its south end and wider up at the northern, kind of in the middle of the property. Did you construct that driveway when you owned the property?
The driveway as it is in this picture, we constructed that.
Okay,
When we purchased the home in 75, it was a one-lane driveway.
okay. So as we look at this picture, we see there's a single vehicle parked in the wider portion.
Correct.
Is that the location of where the original driveway was?
Yes,
Okay, and then you expanded that driveway to the east, correct?
correct. So we could park a second vehicle because I drove to work and my wife needed a car.
Okay. Now, this fence row that I've talked about, would the fence row have run through the middle of this widened driveway? Or was it right along where the original driveway was?
The fence row would have ran right along the original driveway.
So do you see my arrow on my?
Yes,
Okay, that's where the original fence row was?
yes, it was in line with the trees there in back.
Okay, so
Came
the
straight
line
out to the road.
like that.
Yes,
And it's a bit obstructed, but you can see the narrower portion of the driveway coming out to Wooden Road there.
yes.
Did you get the permission of the Barnharts to remove the fence row?
Yes, we went to them and asked if we could remove the fence row at our expense to make a wider driveway to park in.
Okay,
And they said it was all right with them. We took the trees out and the rocks and everything that was in the fence row and then seeded it to grass.
okay. Prior to taking the fence row out, were they cultivating right up to that fence row?
They were cultivating on the the east side of the fence row, yes.
Okay, so over in this area, at one time, was cultivated about right up to where that tree is in the back?
As close as they could get to it with machinery.
Okay, when you took the fence row out, and did you then expand the driveway in an easterly direction?
Yes, we did at the north portion of it
Okay.
to make a spot for a second vehicle.
Right. But you didn't, the two vehicle wide driveway, when you sold the property to Mr. Burrows, didn't go all the way to Wooden Road, correct?
Correct.
So when his testimony that everything is just as it was when he bought it, that's not exactly true, because he's in fact expanded this double driveway to go all the way to the road, correct?
Correct.
All right. So when the Barnharts agreed to let you remove the fence row, they didn't deed any property to you, did they?
No,
They just gave you permission to expand your driveway and allowed you to mow the area that was.
yes, we planted grass there to keep the weeds down and to make it, the appearance, to look good.
Okay. Now, when you sold the property in 1985, we've heard testimony from the realtor and from Mr. Burrows. Do you recall having a meeting with the two of them prior to Mr. Burrows closing on the purchase at the home there?
I don't recall being with them when Mr. Cunningham was showing the house or anything.
Okay. Do you recall making any specific representations to Mr. Burrows about where you believe the boundary lines of the property were and what he would be buying from you?
No, I don't.
Okay. In this picture, up to the north on kind of the northern part of the mowed area, there appears to be a bit of a cutout. Was that a garden of some sort?
Yes, my wife thought she needed a garden.
Okay. Sounds like the garden may not have been the best undertaking.
Well, it wasn't my idea.
Okay. Was that garden there when or was that sort of rototilled or smoothed out area for the garden there when you sold it to Mr. Burrows?
I believe it would have been.
Okay.
Yes.
And again, was there any discussion about whether that was on your property or you were selling that to him?
No.
Okay. So, and again, at the point in time that this picture was taken, you didn't own the surrounding farmland, correct?
Correct.
Okay. And so you're sort of the Barnharts just sort of allowed you to mow out there and use that property that way?
Right. They allowed us to keep it mowed down and to keep the appearance looking nice.
Okay. So subsequent to selling it to Mr. Burrows, and you acquiring either by lease or by ownership the surrounding farmland, did you pretty much continue to cultivate the property as it had been historically?
Yes.
Okay. Did you believe that your western boundary of your farmland down here on the southern part, did you believe to be it bounded where this grass is depicted, or did you believe you owned further over based on your previous experience with the land?
The farmland itself or the house property?
The farmland, because you had sold the house by the time
Okay.
you bought the farm.
No, I believe that the farmland went over to the driveway.
Okay, the driveway as it was when you sold the property?
When I sold it, yes.
Okay. Now, do you mean the entire driveway or just the part that before you'd removed the fence row?
No, I'm speaking of the south end of the driveway.
Okay, this is down here.
Yes.
Okay. And there was never any specific discussions either before or after you sold the property to Mr. Burrows or after you acquired the surrounding farmland up until a couple of years ago about exactly where this boundary was, correct?
Correct. At the time, it kept getting wider, farther to the east.
What kept getting wider?
Well, the part that was not being worked as farm ground. And a lot of that was done as we tried to work and keep the ground smooth between the grass and the crop. We would actually have to leave a strip to smooth it out because our equipment would hang over the corn planter. It was wider than the row.
Okay.
So it would actually hang over into the yard part if we went right to the edge.
Okay. So you didn't cultivate all the way up to your westernmost boundary in this area in an effort to be neighborly to Mr. Burrows?
Correct.
Okay. And you became aware at a point in time that he had expanded this driveway, correct?
Yes.
Okay. In fact, I think we heard him testify earlier that he had to put in some kind of a culvert, and I assume that culvert would have been right by Wooden Road, correct?
Yes.
Were you aware that he installed a culvert there?
I don't remember that I was aware of the culvert. I'm sure that the road commission made him put a culvert in
Okay.
if he got a permit for the driveway.
And the driveway was, he expanded it so that he could more easily get his car haulers in and out?
Yes.
And that expansion of the driveway really didn't negatively impact your farming activities?
No, not at that point.
So, you just decided you knew it was happening, but you weren't really concerned because it wasn't adversely affecting you?
Correct.
Is it fair to say that the tensions in this matter kind of arose back in the fall of 2019 as a result of a survey that you had performed?
It started in the spring of 2019.
Okay, can you tell us a little bit about that?
I was in the field, working the field, and I noticed that he had gotten over farther with some of his proper. He was piling stuff on in the back corner,
Okay,
and it was getting over farther into the field
when you say the back corner, are you referring to
by,
this,
by the trees.
by the trees?
Yes,
Okay.
on the east side of the trees.
Okay, and I believe we've seen some pictures. There was a car there at one time, and when you sold him the property, it's obstructed by this tree, but there was an existing shed that is reflected on both the surveys, correct?
Correct.
And it appears that that shed encroaches upon your property by somewhere between 0.8 feet and 1.3 feet. Is that correct?
Yes.
Okay, and then there's a smaller structure that wasn't there when you sold the property to him, correct?
Correct. There was only one shed.
When did the other one get put up?
I don't know the year.
Okay,
It was after it was sold.
okay, and that one obstructs between 1.9 and 2.2 feet, correct?
Yes, by the survey.
Okay. And again, the placement of those particular buildings at that time didn't really adversely impact your cultivating activities, correct?
Correct.
You just sort of tolerated it and allowed it to continue?
Yes.
Okay. Mr. Burrows testified that he had placed stakes in the ground at the corners of where he believed he owned, which he's testified was the mowed area, or otherwise depicted as his occupied area on his survey. He says he placed those shortly after purchasing the property in 1985. Do you recall seeing anything like that?
I do not recall ever seeing anything. I don't recall ever removing anything from the corners.
Okay. Now then in the spring of 2020, you'd had your survey prepared already and he had a survey prepared, correct?
Yes.
And at that time, he did put in some wooden stakes with flags on them, correct?
Correct.
And is it your understanding that either your son or your daughter removed those and tossed those back on his property?
Yes, they did.
Okay.
They were actually in the parts that we had planted corn in
So you had in the
previously.
planting season of 19, you had planted corn into areas that are now claimed to be the disputed area, correct?
Yes.
And that was, you planted corn in the spring, and then it looks like in the fall, you got your survey done, and the following spring, Mr. Burrows got his survey done, correct?
Correct.
Talk to me a little bit about the decision behind expanding what you were cultivating in, because that appears to have occurred, some of it at least, in the spring of 2019.
Yes, as I was saying, that when I was working the field, on the west side, he had a barrel setting on the corner. It was actually right on where I couldn't even go through with a disc as I was using. I had to get out of the tractor and remove the barrel so I could continue going. And when I got onto the east side, there was also some things that were laying in the actually weeds, because where he put his stuff, he didn't actually mow. He just let the weeds grow up. And so I moved over probably 4 to 5 feet with a disc toward the house and dug it up so we could plant corn, knowing that it was on my side of the property.
Okay. Was there a point in time in about 2012 where you cultivated perhaps a little bit less in this area than you had previously?
When we went to a 12-row planter from a 6-row planter, we start on one side of the field and work over. And when we got to where we came straight through on the east side of the property, I was going to have to double rows, about 9 rows of the 12-row planter. So I decided to move over toward the west or toward the east farther and leave a little more area that I didn't plant, just so I didn't have to double the rows. Doubling the rows doesn't get you anything. It just costs you money.
Okay.
Use twice the seed, twice the fertilizer, and you don't get any, there's so many plants there, they don't produce anything.
I understand. So after you, about how many feet less were you planting when you made that decision in 2012?
Well, 3 rows would be 30-inch rows, so that's 90 inches, which is 7 feet,
7
8
feet.
feet.
Okay. After you stopped planting there, did grass begin to creep into that area that began to be mowed by Mr. Burrows?
Had been smoothed out by the disc, so the grass or green stuff started growing, and I believe Mr. Burrows started mowing it down.
All right.
What
And again, that was in 2012, correct?
Yes.
Now, in the spring of 2020, did you or either of your children who are kind of running the farm operation now disc or plow up additional property in this area that had not been plowed previously?
Yes, they worked over farther towards the property lines that we owned.
Okay, and is that similar up here on the north side as well?
Yes, the north and the east.
Okay, and on the
Or
west,
excuse me.
north and the west. So in
Yeah.
all areas, you began to plow areas you hadn't before.
Closer to the line, yes.
Okay. And just to reiterate, prior to that time, and for many, many years, did you know you weren't farming everything you owned?
Yes.
And up until recently, until Mr. Burrows put his own stakes out there, he hadn't really interfered. What he was doing there wasn't interfering with what you wanted to do with your property, correct?
To a certain point, there's, we knew he was piling, well, I shouldn't say piling. He was putting vehicles that he wasn't using on our side, and we knew they were on our side. We didn't ask him to move them. We just kind of put up with it. We were trying to be neighborly. We run a dairy farm. We have to get along with neighbors. So we were just trying to be neighborly, and we didn't ask him to move them. But there comes a point in time where, when he came to my house and started yelling at me because I had moved over 4 feet with a disc, I simply told him that if I was on his property after the survey, that we would put it back to grass and smooth it out, and he would be able to mow it again. So we decided to have a survey done.
I'm not sure if the court needs, I think we'd stipulated to the admission of both surveys, so I don't think I really need to lay a foundation or move to have that admitted. Is that correct, Your Honor?
Yes, both surveys have been admitted.
Okay. We would move for the admission of, we'll call this defendant's exhibit number 2, which is this aerial photograph that that Mr. Drake has testified to.
Any objection, Mr. Trueshan?
None, Your Honor.
Exhibit 2 is admitted.
At this point, I have no further questions for this witness.
Cross-examination, Mr. Trueshan.
Thank you, Your Honor. Mr. Drake, as I look at the photo, are you seeing the photo also right now?
Yes.
Okay. I see that there is, I mean, the lawn seems to be well manicured in that. That was your doing around the property?
Yes.
Okay. And I see that in fact, the driveway, there's only one driveway to this property.
Correct.
You would have never sold property, be it to either Mr. Burrows or anyone else, if in fact you knew the driveway was encroaching on somebody else's property, would you?
At that time, I knew that the north end was over the line. From what I bought, the north end of it was expanded by us.
You talking about the north end of the driveway?
Yes.
Okay, let's talk about for a second the south end of the driveway by where it connects over the last X amount of feet to Wooden Road.
Okay.
That by your map and survey, Mr. Drake, and by ours, both indicates that in fact it is over quite a few feet at the right-of-way line over by what your surveyor indicates is 6.6 feet. Over at the end of the property on Wooden Road, some 18 feet. You don't disagree with the survey you had done, do you?
I don't disagree with the survey. I disagree with what I sold at the time that I sold it.
Okay. And
When I sold it, it was a one-lane driveway off the road.
well, I understand, and I'm not to that top part yet. I'm just dealing with the bottom part where it connects to Wooden Road.
That's where I'm speaking.
Okay.
It's at Wooden Road, it was only one lane. It wasn't a two-lane driveway.
And you're saying it's a two-lane driveway now?
Yes.
In regard to the property, as I look at the photo that's up on the screen right now, it is much wider at that top end, so you can get 2 or 3 cars there, correct?
Correct.
That property to the east of that, the Barnharts, when they sold you the farmland, owned up to that property, is it correct? Or further? Further west?
When the Barnharts sold the property, they owned to where the property lines are on the property of the house.
Well,
Okay. Well, I want to just make sure, because it sounds like the Barnharts, when they sold you the property, also didn't, and I don't know why my computer went out. Can you hear me?
Yes.
Okay, I just don't have any screen. I don't know why. All right. I don't know if you can see me, but I just have a blank screen. So my,
Check the cable at the back of your monitor. Sometimes those wiggle loose.
yeah, I'm looking right at it and then touched it, so. Okay. Anyway, long story short, Mr. Drake, I just want to make sure we're talking about the same thing. Is that when I look at the photograph that my client has, the photograph of the Burroughs home of 1989, do you have a copy of that, or can you see that?
I don't have a copy of that, no.
Okay, all right. Let me ask you this. This property, you don't disagree you sold Mr. and Mrs. Burroughs the property, correct?
Correct.
And it's your position that none of the property from the property line is in fact, there we go. Is in fact the Burroughs's, that's all your property. Is that correct? All that grassy portion that I was looking at,
Yeah,
you're indicating you maintained that when you owned the property. That would have been also the Barnhart's property when you bought, correct? That
yeah,
makes sense?
yeah,
Okay. So and again, I just want to make sure that you were doing the same thing that Mr. Burroughs was doing, and that is maintaining, looking after, taking care of that property when in fact it was Barnhart's property.
correct. I had
Okay.
gone to them and talked to them
Okay,
and got
And-
their permission.
okay. To maintain that portion?
Yes,
I see. But you knew and they knew that in fact that property was actually theirs.
correct.
All right. So let's talk about the north side. I see you indicated that in fact, there we go. I see in fact that the north side has the garden out there. And Mr. Burroughs indicated he had a garden out there. Do you know where Mr. Burroughs's garden was if you've seen it?
Do I know where his garden was?
Yes. With seeing the property and plowing around the property and that, did you see Mr. Burroughs's garden?
Yes,
Okay. Was it to the back there where your wife has hers?
yes.
Okay. Same area and location then?
Same
Approximately.
area. I don't know if exactly.
Okay. And where the trees are, sir, in that right-hand upper corner,
Yes,
that, let's assume for a second, that one big tree you said fell and was moved away. Those two sheds that are out there, you're saying only one shed was there at the time you sold to Mr. Burroughs?
correct.
You know where the other shed came from?
I would suspect that Mr. Burroughs put it there.
Behind those sheds, sir, Mr. Burroughs had cars, car parts, and some other remnants of automobiles, as well as some things stacked up there. Do you recall seeing those when you were plowing?
Yes,
And is it your consideration that that was your property at the time? He just decided to put everything there, or put many things there.
yes.
Okay. Did you ever tell him to move it off? Get it off
No,
your
I-
property?
No, I didn't.
Okay. Did you ever send him any correspondence or have an attorney send him anything like that at all?
No,
But you knew that in fact it was your property.
yes,
Okay. Same way, sir, on the east side, just a few times that I have been there, that up and down by the driveway there, right there, Mr. Lovinger is doing a wonderful job with that.
mhm,
That property, of course, is what my client indicates that he maintained, and to people's detriment and everything else, that in fact, it should be his, and you're staying. Did you recall him parking his trailers, the truck, the semi, everything else on that grassy part?
no.
You don't recall that?
I recall that apparently he made the driveway wider, and that's where he's parked his semi.
He didn't park it on the grass?
No,
He didn't park any of his personal vehicles or trailers or anything else on the grass?
well, he's had personal trailers on the grass.
Okay.
But he didn't park his semi on the grass.
Okay. Now, I'm looking at this, Mr. Drake, and it's indicated that in fact he put a culvert in there. That culvert would have been on your side also? Is that correct?
By the survey, yes,
Okay, all right. Because it was east of where the driveway is now, correct? His personal driveway, if you go east with the pointer, there you go, there. Is that where the culvert is that he had put in?
the culvert is probably the width of the driveway
All right, so,
that he had put in.
okay, so the driveway is there that he's been using. And then it's to the right of that on my screen, or to the east is where the culvert was was dug in and the pipe was laid. Is that correct?
He would have had to put a culvert to full length of the driveway that he made, yes.
Okay, all right, okay. And is it your testimony that that was still your property? Correct?
Correct, because
All right.
like, okay,
All right, I just want to make sure that I've got exactly the facts of what's transpired in regard to that. Now, did you ever say anything to him about that? Why are you putting a culvert in? You didn't get my permission. What the heck are you doing? Anything like that at all?
no,
Okay. Did you talk to his wife if she was there about putting that culvert in, or anybody?
no,
You never took any enforcement action to stop him from putting the culvert in?
no.
Okay. Now, you spoke, Mr. Drake, about a fence. The fence would have been on the east side, you're saying, east side of the property here?
There was never a fence, there was a fence row.
A fence row. Tell me the difference between a fence and a fence row.
You see it as the trees?
Yes.
Okay, that's part of the fence row that's in the field. Yeah, on farther north, there's a fence row that ran through the field. And that's what we took out in the grassy area and where the driveway
So
lays.
I'm familiar with decorative fences and cyclone fences. By saying fence row, Mr. Drake, is there actually a fence there?
There's trees and rocks. There might have been an old stave fence.
I see. Okay, so there, all right, so
It's not workable, it's not mowable.
there wasn't actually a fence there, either wood or metal or anything like that, just what you consider to be a fence row down through there
Yes,
with some other objects. Okay. All right.
right.
So it wouldn't take much. Obviously, you sold the property to Mr. and Mrs. Burrows in 85. When did they take out the fence row?
We took it out before 83.
I see. Okay.
Because
So
it's
they had,
gone.
so he wouldn't know anything about that anyway. He wouldn't have any knowledge about that because it was gone when he bought it, when he and Mrs. Burrows bought.
Correct.
Okay. Was there any fence row to the north and or to the west?
To the north,
There was to the north. What kind of a fence row again are we talking?
trees and rocks.
Okay, all right. And that might have been removed. I don't remember seeing that. That might have been removed though also, correct?
After we purchased the ag property, we took out all the fence rows.
I see. Okay, all right. And you purchased all the surrounding property to three sides of Mr. Burrows' property in 1990?
I believe it was right around 1990.
How long prior to that, Mr. Drake, were you conducting your operation around that property? 10 years before that?
I don't believe it was 10. It might have been 7 to 7 years,
Okay. All right.
somewhere in the early 80s.
Is when you started the farming operation?
This is when we started leasing the farm property, yes.
Okay, all right. Prior to that, were you also around all this property? I mean, you
Well,
would have seen
I
it.
lived there.
Yeah, I was gonna say, so when did you move into the house there?
75,
Okay, so since 75, you've been familiar with all this property.
yes.
All right. Mr. Drake, as I'm looking at, do you have a copy of your survey?
Yes,
So while you say that in fact the driveway was expanded potentially by my client, I don't recall that testimony coming forward, but let's, for the argument's sake right now, as you look at your survey and you start, let's say from the north part where it says gravel drive,
Mm-hmm.
it says, Mr. Drake, on there, over 1.3 inches. Would you agree that's what it says up there?
Yes.
Okay, and then as you come down, the lines again, and you don't even get to where it would have been expanded, it says over 6.6 feet.
Well, it was expanded. As I stated earlier, when I owned the property, there was only a one-lane drive. It was only one car width from the road in.
So I guess let me make sure my question corresponds with this. Is that what I'm seeing from the drawings is that a one-lane gravel drive there, you're saying that he would have never been over at all had he not done anything to it. And you're saying he expanded that.
He expanded from the picture of 83, from where we expanded at the north. He expanded from there to the south to the road.
You're saying he expanded the whole driveway?
Yes. To make room to park his semi and a vehicle side by side.
Okay. And then to the, where it says Drakeland Farms, to the east,
Mm-hmm.
he's indicated that in fact, he believes he should have 40 feet there in regard to that. You don't disagree. You don't disagree that in fact, that has been until very recently left alone and been all grass as you had it when you owned the property.
It was never 40 feet at the time it was purchased.
No, I'm saying that's what he is saying. But what I'm saying is it was always treated the same. You planted grass, you cut the grass, things like that, both when you were there and when he was there. You don't disagree he maintained that property. Again,
I don't disagree he mowed that property.
okay.
I disagree with the width.
Okay, I understand. I understand. In regard to the shed, sir, or the one shed you say that in fact, at the top, they indicate that the shed is over anywhere from 0.8 feet to 1.3 feet in regard to that. Did you know about that at all?
I did not know it was over. I didn't put the shed there. The shed was there when I bought it.
Okay.
While you're on that screen, which of those sheds was there when you bought it?
The one on the east side,
The
that
large,
one there, that one there.
the larger one.
Yes, the larger one.
Now, you heard Mr. Dennis, the realtor, his last name escapes me, indicate that in fact, when he looked at the photograph that my client had, an aerial photo, that that's the way the property appeared when he sold the property.
He's mistaking if he's saying the driveway was 2 lanes.
Okay. Nothing further this witness, Your Honor.
Redirect, Mr. Levenger?
Just a couple of issues. The driveway that's depicted on the Wolverine survey and also on the survey done by Mr. Lazinski is what, for lack of a better term, we're going to call the double wide driveway that goes all the way from the road up to the north, correct?
Correct.
Okay. When you sold the property to Mr. Burrows, again, the driveway down here at Wooden Road was only the width, one car width or maybe 10 feet perhaps, enough for one car to go up and down, correct?
Correct.
Okay. And I'm not sure how easy my access is going to be to getting that picture up, and maybe that's not all that important, but you were aware and you felt as though the part that Mr. Burrows was mowing was at times expanding in its width.
Yes.
Okay. But again, it wasn't at that time interfering with your agricultural use of the property and being a dairy farmer and trying to keep the peace, because neighboring a dairy farm is not always pleasant. You didn't want to make a big fuss about that because it really wasn't interfering with your crop cultivating, correct?
Correct.
Similarly with his driveway, you knew he was a car hauler and you saw what he'd done, and it didn't really strike you as bothersome or interfering your property rights?
Correct.
Do you happen to know whether the vegetable garden that your wife tried to develop that was up there on the northern portion of the property, is that still there, or did Mr. Burrows sort of abandon the gardening business as well?
I don't believe there's a garden there anymore.
Okay. It's probably grass.
Yes.
In fact, the pictures we've seen, because there was a picture of some recently plowed property up on that northern boundary that your daughter plowed, would indicate it was grass. Is that correct?
Correct.
I have no further questions.
If so, if you could exit your screen share, Council.
Sure.
I need to pull up a drawing.
Oops, did I do something wrong?
I see what I did. Hold on. Okay, no, you're good. Now I want to screen share. If I can find the exhibits. I've got too much stuff open. Hold on. There we go. Well, I thought I already had it open. Let me try. Okay, here we go. Okay, I wasn't remembering this, photograph as vividly, but it looks like at this point, the driveway is still one lane at the road.
Which photograph are you referring to?
Uh, it should be on your screen. Do you see it?
No, it's not.
I don't see it.
No.
Oh, no. It tells me I'm screen sharing. I don't know why you guys can't see it. I can see it. I must be doing something wrong. Hold on a minute. Do you see anything shared on the screen right now?
There's an email and it looks like it has an attachment of some image.
Okay, I opened up that attachment. Let me try again. All right. I think I have to go into it a different way. Here we go. All right. And now do you see it?
There it is.
Yeah.
Yes.
Okay. So let me get this out of the way. All right. So as I look at this driveway, when I had first seen it, I was thinking it was this width at the back all the way to the road. But now as I look more closely, this appears to be grass in this area that I'm running the cursor around. So at this point, does it appear to you that at least at the road, it's still just a single width driveway?
That's a question for you, Dan.
Oh, excuse me. Yes, I would say that looks more like grass than gravel.
Okay, and it was sometime, obviously, after you sold it and after this photograph was taken, that the boroughs expanded, put in the other culvert and expanded it to double wide down at the road.
Yes.
Do you have any recollection as to when that was done?
This picture is supposed to be 89. Or is
Yeah,
it
that's
say-
represent, I can't quite make that out, but
89.
Okay. 89?
Correct.
I don't know what year he would have expanded it, no. It was after it was purchased by him.
all right, just a second, let me look at my notes. At the time that you expanded the driveway at the north end, you were also the person who was farming the adjacent farmland, correct?
No, I'm not sure that I was running the ground at that time. We expanded the north end probably somewhere between 1975 and 1980.
I see. And it was in 2012 that you switched to the 12-row planter?
Yes,
Before that, the farmed area would have been approximately 7 feet closer to the mowed area, to the borough's property?
it would have been, yes, at least that or more. Like I said, gradually gets wider, just by the way we work it, trying to keep the ground smooth. We try to level out the ground so there isn't a hump between the corn and the grass that grows to weeds.
Right, but when you moved to the 12-row planter, there was more than just a gradual movement.
Yeah, I actually moved over farther that year.
Okay.
Just to-
Was that true all the way around the parcel or just?
No,
Just
just on the east side.
The boundary as depicted in the drawing that's currently on the screen on the north and on the west wouldn't have changed as a result of the 12-row. I said boundary, I meant the edge of the field. That wouldn't have changed as a result of the moving to the larger planter.
No.
Okay, thank you. Redirect, Mr. Lovinger?
Just a couple, as we're looking at this picture, Dan, and I'm not sure if my cursor is showing, but up at the north part, north of the above ground pool, it looks like you can see where the crops are planted and they look to be kind of going right through what may have once been that garden.
Yes.
Okay. And over here on the west side, there's a little bit of mowed area between these trees. That's been consistently, you've moved over perhaps a little bit further since you had your survey?
We could have come back to the east a little more since the survey, yes.
But are these trees still in there?
Yes.
Okay.
I believe so.
Okay.
Honestly, I don't pay that close attention to people's property.
I understand even if you owned it, making that tillable would be some undertaking because you'd have to get rid of the trees and the roots, right?
Right. Correct.
Leads to my next question. Up in the upper right corner are these big trees that are depicted not only in this picture, but the picture that we had admitted, the aerial view of the house when you lived there up here. And
Yes.
you have never cultivated very close to those trees, even though they're on your property, correct?
We can only get so close with the equipment, yes.
And the reason for that is you begin to run into things like roots, correct?
Well, yes, you end up with roots and also tree limbs that hit the tractors and
And fall on the corn.
well, they don't fall on the corn, they just smack the tractors and you
Right.
try to stay away from hitting tree limbs and stuff.
Right. And the roots are a threat to your plows and discs because they can cause damage, correct?
Yes,
So that you deliberately haven't gotten any closer than that to the trees because it's just not practical.
correct.
But by not planting there, it wasn't your intention to abandon that property or give it or surrender it to anybody, correct?
No, that's like any fence row around the outside of your property. You can only get so close to them.
Okay. As we look at this picture that's on the screen now in the northern portion of this driveway, right over here, based upon your survey, that corner there where there appears to be something parked, that's at that point, that's about 1.3 feet over onto your property based on the surveys, correct?
Correct.
Okay. And again, as it proceeds to the south, the encroachment becomes wider and then really fans out at its extreme southeast portion, correct?
Yes.
Okay. Okay. I have no further questions.
Nothing further this witness, Your Honor.
Okay, thank you. Any further witnesses, Mr. Lovinger?
No, Your Honor, anything I had, I think would be duplicative, so we're prepared to go to argument.
All right, unless Mr. Trushan has some rebuttal testimony to offer.
I do, Your Honor. Can we call Mr. Burrows back to the stand?
So, Mr. Burrows, you can still hear me?
Yes, I can.
Okay, and just because we've got several Mr. Burrows who've testified, you are,
Donald.
you're Donald, okay, and you understand you're still under oath.
I am, and I don't have no Zoom.
Oh, I'm sorry to hear that. We won't be able to show you any pictures, but,
I can try to find them.
No.
well, yeah, you have sets with you, so if Mr. Trushan, if you want him to refer to an exhibit, you'll be able to do that.
I don't think I'll want that, Judge. I just have questions for clarification.
Go ahead.
Mr. Burrows, you heard the testimony of Mr. Drake,
Yes,
and he indicated that there was only one shed on that property when he sold the property to you.
that's correct.
So there was only one shed there?
Yeah, it's the one on the northeast side.
Okay, where did the other shed come from?
I put it on there
Okay.
in
all right.
line with the other shed.
I see. Okay, I just want to make sure, because that was his testimony. I wanted to make sure that was your recollection.
Correct.
In regard to the driveway, sir, you put in a culvert
Yes,
and you had a metal tube for the culvert put in, is that correct?
yep. So my semi could get over it, my car hauler, because I put 80,000 pounds over it.
Is that, sir, is that culvert right next to the driveway?
Yes, it is.
All right, so it's not the driveway. You didn't just put a culvert at the end over the driveway. You actually put the culvert in further east over what you believed was your property, correct?
Yes,
Okay, over that, again, you're asking for that 40 feet. I'm looking at the certificate of survey, and it's over that portion is where you're saying you put it.
yes.
Now, Mr. Drake indicated that you never asked him for permission to do that, correct?
No, because I assumed it was my property.
I understand. My next question is, at the time when they were putting in the culvert and digging that up and doing that, they were still farming next door on the Drake properties, correct?
Right at the line, yes.
My point is that the tractors and people, Mr. Drake or his daughter or son or people there would have seen at the more and more they drove around cultivating that farmland, they would have seen that you put a new culvert in there.
Yes, you bet, they sure did.
Did you ever speak to Mr. Drake about putting the culvert in?
No,
Okay, and it's indicated by Mr. Drake that in fact, on the photograph, sir, of your home, the aerial photo, that you expanded the driveway to 2 lanes all the way to the road. Is that correct?
you can get it was the same thing that when I bought it, you could get 2 by side all the way from the south to the north, and I had railroad ties. You can see those.
Okay, I understand. I see the railroad tie. But did you expand the driveway a second whole car width, the whole width of that driveway?
I did probably about 5 feet to get my semi truck over on the east side where I parked it. See the railroad ties?
Yes.
Where the cars are at in that boat?
Yes.
And I covered,
Yes. Yep.
I got a tarp over it on the north side. That's how far, and then clear on the back, that black pickup truck. That's just as far as I ended up expanding that. But I didn't want people to go ahead, because I had Mr. Drake go ahead and drive his manure spreader into my driveway onto my east side right there and go in that field.
Okay.
Tell him this has got to stop.
So
He did.
to make sure I understand your testimony, that Mr. Drake indicated, as you look at this, two lanes, it looks like, that does not go all the way to the road that way?
Yes, it does.
It does. Okay, just that, you didn't expand any more.
No,
Okay. When you bought the property, was it one full lane or two lanes?
about a lane and a half.
Okay? So your testimony where you're saying that you expanded it about 5 feet is
Yes,
what you're saying.
correct.
Now, on that photograph, you see the cornfield to the east right there? There's the grass and then the cornfield.
Yes,
You see that vehicle parked in there?
right. That's mine.
Okay, right. Did you ask Mr. Drake if he could park that vehicle there?
No, he let me.
Nothing further this witness, Your Honor.
Just a couple
So,
of
Miss-
questions.
Jake, let me ask one. Mr. Burrows, when did you put that culvert in?
Let's see, when I ended up working for E&L Transport in 1986. Because I kept on driving my trailer tires into the ditch, and it was really tight.
So you bought the property in 85?
Right.
You put in the culvert and expanded the driveway at the road in 1986?
Yes,
Okay, thank you.
you're welcome.
Mr. Lovinger?
Mr. Burrows, how wide is this culvert pipe that you installed?
I believe they come in 5-foot sections.
And how many sections did you install? One? Was there already a culvert there from when Mr. Drake owned the property?
Yes, to get
Okay.
in
And
the
what you,
driveway.
and what you did is you expanded the driveway where it meets Wooden Road in an easterly direction to make it about double the width it was to begin with, correct?
Correct.
So there already was a culvert. You added another 5 feet of culvert, correct?
That's correct.
So based upon that, how do we come up with an idea that your driveway or your culvert extends some 40 feet to the east from the surveyed property line?
You faded out. Can you repeat the question?
Based upon the fact that there was already a 5 or 6 foot driveway that had a culvert when you bought the property, and you testified that you added another culvert, which is approximately 5 feet, so that you could get your trailer in there safely. So that you've expanded, 5 or 6 feet to the east at the roadway. But you're asking this court to say that you now have ownership of approximately 38 to 40 feet from the eastern surveyed boundary line. How do we get there based on the fact that you expanded the driveway 5 or 6 feet to the east?
I just expanded that culvert 5 feet to get that trailer in, like I said.
Okay.
What more you?
And in fact, according to the surveys that have been performed, where the driveway meets the right of way, it's only 6.5 feet of encroachment. It gets as far as 18 feet over, but I don't know that that's the culvert, because the culvert is located on the north side of the right of way, correct?
The culvert is on the east side.
The east side? Or
Get in that driveway.
isn't the purpose of the culvert to cover a ditch that's between the road and your driveway?
The culvert is for where the water can go ahead and go through.
Right, underneath your driveway, correct?
Yeah,
Okay, so your driveway runs in a north and south direction. And after you purchased the property from Mr. Drake, you expanded the driveway at the right-of-way point by 5 to 6 feet in an easterly direction and had to put in some more culvert so that the water could drain down the ditch that runs at the point where your property meets the right-of-way, correct?
it's correct.
Okay. And again, it's very common in rural areas that we have these little ditches, and it necessitates people putting in culverts so that they can safely navigate and not have their trailers fall into the ditch, correct?
Right, yes.
Okay, right. So, all right. Now you provided some testimony just a moment ago where you indicated that you had been parking a car according to a picture on what may have been some grass. And you said that Mr. Drake let you do that, correct?
He sure did.
Okay. I have no further questions.
Mr. Burrows, I know you can't see it, but I've got a survey on the screen that depicts, it's your survey, the one that depicts the occupied area. And I'm looking down where the driveway meets the road.
Okay,
Okay, do you have that in front of you now?
I got it in front of me. Yes, sir.
All right. You see where the south edge of the the north edge of the pavement is?
On the dirt road?
Well, it says pavement. So you're telling me there isn't any pavement. It must be referring to the improved portion of the roadway. So the edge of the road, do you see where the drawings?
Edge of payment?
It says edge of pavement, but you've just
I do.
clarified there's no pavement there.
Yes, just a dirt road, sir.
All right, so that would be the edge of the road. How close to the edge of the road was the culvert placed?
Road Jackson, sir. I had to get an okay from them, and they came and put it in, brought gravel and put the culvert in.
Oh, okay. So you don't know exactly how far from the edge of the road the culvert is?
No, I do not.
Okay. Thank you.
You're welcome.
Council, any follow-up questions?
No.
Nothing further.
All right, and any further rebuttal testimony, Mr. Truchet?
No further rebuttal.
Okay, I think we are ready for arguments. So, Mr. Truchet, you get to go first.
Thank you, Your Honor. Your Honor, this deals with property. Obviously, you've had hours and hours of this, as well as all the trial briefs and everything else in regard to it. It comes down to, from our standpoint, that my client purchased this property from the defendants some 35 years ago. That in fact, at that time, he walked the property through his testimony with the realtor and with Mr. Drake. Albeit I understand Mr. Drake, I believe, has indicated he doesn't recall that. It would make sense to me, though, there would be no reason for my client not to indicate exactly what took place way back then, that they walked the property. It would make sense to me as I look at the photos that my client has, as well as the information that the Drakes have, that in fact that property was maintained in the same fashion, in the same location. So what Mr. Drake did is exactly what my client did. He maintained the property, he cut the grass, he used it as his own. He did everything that was asked of him as a homeowner, to the detriment to the people that in fact really had, which was the Barnharts at that time, the ownership My client received a deed in regard to this property that indicates on the certificate of title what he received from them legally. The problem we have, Your Honor, I'm hearing now that for the first time that in fact the driveway was expanded somewhat as it goes from the north to the south. However, we still have, even by the admission of their survey, that in fact, when you look at just the one lane up there, it's over at that point, and at the point at the bottom, 6.6 feet. My client indicates, and in fact, as you look at the bottom, if you look at the marks and you look at that 38.46 feet down there, you're looking at 2/3 of that. I would think 25 to 30 feet of that is where the driveway. Now, if they're saying that in fact 5 feet should come off of that because of the tube that he put in Culvert, I'll let the court deal with that obviously in your own fashion. But what we have, Judge, is a client of mine that in fact believes he maintained, he used, he drove on, it was actual, it was visible to the Drakes, both to Mr. Drake and his family, who were the ones that used that property, that in fact this adverse possession and use by my client was not only open and visible to them, that they could see it. They actually confronted my client finally about this. They pulled out the stakes that he had. They had their own survey done. They, in fact, started going over more and more and more onto the property. If they really thought that was their property, they would have cultivated that as much as possible in regard to that, and they would have told my client to keep his rear end off of it, to not go in, have an attorney write them a letter, say something to them. They had an affirmative duty, if my client was a trespasser in regard to that, to do that. I've heard that, in fact, they did this because they thought they just wanted to be neighborly. I think it was open. I think it was notorious. He did it to the detriment of the Drakes, of who he bought the property from, actually, in fact, indicating that his motto was he was going to put his own culvert in. He never asked for permission. The Drakes never stopped him, with full notification as they're watching this go on. In regard to the sheds, Judge, there's no issue that, in fact, one of the sheds that was on the property and owned by the Drakes prior to my clients is over by some 1, 2, 3 feet or more. The problem we have also, Judge, by selling this property from the defendants to my clients, places them in a position now with that shed being over, that they either have to rip that shed down, should they want to expand or sell the property, and if there's a 10 or 15 feet rule in regard to the townships being close to a lot line, they're going to need to, in fact, destroy that shed and go from there. Again, my biggest point is the Drakes were the ones that sold my client the property. And now they're the ones that indicating that they get the property from the Barnharts. Well, something must have happened, because the Drakes had no issue in doing whatever they were doing to the detriment of the Barnharts. And now my client is doing the same thing to the Drakes in regard to that, since they've gotten the property. And what they're doing is indicating, this is what's mine. This is where your property needs to be. This is where your equipment has always gone. It's never come on my property. And now indicate that, in fact, we shouldn't have had possession of that property. On all three sides, my client maintained it. He used it. He put a garden in. He treated it as his own. It was continuous, Judge. There's been no interruption. You've heard no testimony. It was exclusively to my client, not some third party, and it was hostile. And hostile, Judge, does not imply ill will, as the statute indicates. It is just inconsistent with the rights of the owner without permission, either asked or given, which is a big rule here. My client didn't ask. They never gave him permission. They let him, in fact, treat this as his own, every bit of it. Your Honor, I firmly believe that it meets the task in regard to adverse possession, that my client should be awarded this property as he meets the criteria of all 9 of these provisions. The boundary line, I would argue, Your Honor, may be established where the line, in fact, is there for 15 years. It doesn't mean marking. There's nothing in the statute says it has to be memorialized by a stake, by a fence, something like that. I heard the testimony that, in fact, I put a fence up there or a fence row. Being from Detroit, I have no clue what a fence row is. You either have a fence or you don't. And my answer was, what is that? Well, there were things that my client didn't even know. He wasn't there. They were removed prior to him ever purchasing. So if the Drakes thought that was the area, so be it. But that was not communicated to my client in any way, shape, or form. Everything you see here is what we have, is what you get. My client firmly believes that. He takes over ownership. He treats it as his own. He does everything to it as if it's his own. He never relinquishes his possession or ownership. In fact, to what he believes is a trespasser, the Drakes, he says to them, I'm putting in new stakes. Don't go here. Keep your equipment off my property. You stay on your side, I'll stay on mine. He must have said that 10 times. That's classic adverse possession. At no time after that, you would have thought the Drakes would have sent a letter from council or from them or put up stakes in regard to that and then decided where, in fact, that would formally be. But they didn't do that. They didn't do that because they were acquiescent in my client having adverse possession of that property. For legal sake, Your Honor, to maintain possession and recover, as you know, it must be 15 years plus the provisions that I've indicated. I believe we've met those terms. I believe we've met the terms of hostile, indicating what that is. I asked the court to indicate that, in fact, these rights have been inconsistent with the right of the owner. No permission was asked for, no permission was given. My client was entitled to ownership by the cause of action that we've indicated, Your Honor, and I would ask when you review all the photos, all the drawings, all the information that you've heard, and you fetter out exactly what transpired here and why my client would believe that and why my client would act that way to keep the rightful owner off his own property is clearly adverse possession. Now, I firmly believe no matter what, Judge, you'll have to deal with the shed that obviously is over to the north side and have to deal with the driveway in regard to this, reference my client and what he's placed there and adding the 5-foot tube. But I think when you look at all the evidence, it's clear to see for all this time period, this just wasn't a 15-year and we rushed right out to the courthouse. This was 35 years in the making, Judge, of my client treating the same and the same owners, the Drake, watching my client treat it the same. And now here we are. With that, Your Honor, I ask that, in fact, you grant the position that we've asked for contained in the survey and certificate of survey by Wolverine, as that's the property my client asked for. I leave this in the sound discretion of the court, Judge.
Thank you. Mr. Lovinger?
Thank you, Your Honor. Just a couple of things preliminarily. I think this case, there are, I guess, 3 focal points that the court should look at, and that could perhaps be treated differently and perhaps need to be treated differently. The driveway in the southeast portion, it's clear that that's been there for a while. It appears to encroach when we reach the edge of the right-of-way by some 6 feet. When we get down to the, to the south line of the, or perhaps the other side of the right-of-way, it's wider. Certainly, there were steps taken by Mr. Burrows to install that, the culvert. And it appears the Drakes were aware of that. Their position has always been that, they realized what he was doing. I think they perceived it was on their property, but it wasn't interfering with what they had purchased the property for, and that was to cultivate. You've heard a lot of testimony from Mr. Drake about his philosophy on being a good farmer and being a good neighbor. Being a good farmer means that you smooth out the edges of your fields so that they're aesthetically pleasing and also prevents some weed development. And that when you do that, grass can grow. And he, you know, the fact that Mr. Burrows willingly wanted to mow that, again, didn't interfere with the farming operations of the Drakes. The driveway, the testimony regarding the fence row is important because there's an indication there that Mr. Drake knew where the property line was when he lived there, got permission to remove the remnants of this fence row so that he could expand the driveway on the northern portion of the driveway. But when he sold the property to Mr. Burrows, it was only a double wide driveway on the northern portion. Mr. Drake then sought to expand it, which he did. But even so, the expanded driveway only encroaches 6 to 10 feet on the southern portion. With regard to the shed, there are 2 sheds, but the shed that was there when the Drakes sold the property, it does in fact encroach. They were aware of the shed. I don't think they were aware of the encroachment. Again, based on their philosophy of how they farm and the proximity of that larger shed to these big trees, which Mr. Drake has clearly testified why you can't cultivate very close to these trees because of root issues mainly, it didn't interfere with their use of the property. There's zero testimony that meets all of the criteria for adverse possession with regard to the western boundary of the property. Nothing took place up there. Now there's contradicted testimony, and it was really a little unclear from Mr. Burrows. He claims he put some stakes out right after he bought the property, but it appears if he did, the Drakes just pulled him right out and said, no, you're not, that's not the boundary line. We're going to keep farming. He then, after he had his survey done less than a year ago, put additional stakes out, which were taken out. Frankly, his putting of the stakes out in the last year is probably the most hostile thing that he has done. As Mr. Drake testified, he was trying to be neighborly. He knew where the property lines were. He did not propose to cultivate all the way up to his property line. And in fact, in 2012, for a period of time, actually cultivated about 7 feet less than he had historically, just because of some use of a planter and some farming inefficiencies. And again, I think it's telling that one of the last pieces of testimony that Mr. Burrows provided when we started talking about parking a car on the grass portion of what is the Drake's property, said, Mr. Drake, let me is permissive. All of this mowing and parking has been permissive by the Drakes. Mr. Truchan is mistaken in his legal belief that somebody who owns property, particularly a farmer, is somehow duty bound to cultivate every inch of what they own, and further duty bound to constantly monitor their boundary lines to make sure that there's no encroachment or anyone making use of their property. You're allowed to use the portions of the property you own. Adverse possession is based on somebody for a period of in excess of 15 years, openly, continuously, exclusively, actually, notoriously, and most important, hostilely. And Mr. Truchan is correct. This doesn't have to be fistfight hostilities, but it has to be in a way that interferes with the property owner's use of the property in a way that would prompt them to go to court and say, get off my property, you're trespassing. And in this case, mowing the property didn't interfere with the Drake's use of the property. I would say the expansion of the driveway, since it encroached, perhaps was hostile enough. The Drakes didn't seem to mind it so much because that probably wasn't the area they were entering into the property from. and didn't interfere with their cultivating, and placement of the culvert didn't interfere with their cultivating activities. But what Mr. Trushan is asking for, when you look at this proposed occupied area, is far more than this culvert involved, and it's far more than these buildings to the north involved, and it's far more than anything that's even colorable as adverse use on the west side of the property. The mere mowing alone, which didn't interfere with the Drake's use of the property, isn't enough. There's sort of this reference to somehow representations being made to him by Mr. Drake, but Mr. Drake doesn't recall walking the property with him. I think it's safe to say that Mr. Cunningham, the realtor, although a nice gentleman who appears to like all the parties involved, is in some ways a salesman. And he's saying, well, I just want to make everybody happy. And, maybe I said that it went all the way where it's being mowed, but he understands the peril of making assumptions about where property lines are. And I think it's pretty clear that there was really no direct discussion of where they were. There were assumptions made. Mr. Burrows admitted on cross-examination that he assumed that he owned where he was mowing, and that's not hostile possession. So in my mind, this is an equitable action. And I think equity would direct that in the southeast corner of Mr. Burrows' property, perhaps there needs to be an expansion. But that expansion doesn't need to run from the southern boundary of his property in the same width up to the northern boundary. What it needs to accommodate is this driveway. On the northern portion, it would appear that 2 feet is going to accomplish making sure these two buildings that are encroaching aren't encroaching, no matter how long the smaller one's been there. But it also doesn't need to be from the eastern boundary to the western boundary at that width. It really just needs to accommodate that. So kind of a hybrid type argument, but we would ask the court to deny all of the adverse possession claimed relief with the exception of down at that southeast corner to accommodate the driveway, and a couple of feet to the north. And it seems to me that it probably doesn't need to be more than maybe about 20 or 30 feet in width from east to west to cover where those existing buildings are. And I would ask the court to rule accordingly.
Thank you. Anything further, Mr. Trushan?
Just briefly, Your Honor. Knowledge is seeing. My client indicates under direct oath that in fact he placed those stakes after he moved in. That in fact then sometime after that, the Drakes removed those stakes. They indicated they did, he indicated they did. That's knowledge. That's knowledge that my client to the Drakes is trying to use that property and possess that property of his own. When you put a stake out there, you say to the world and anybody that sees it, this is mine. That's what Mr. Burrows did. He let the Drakes know, this is my property, yours is over there. If in fact that were the case, as we're saying now was, that that's my property, and yes, the stakes were there, and yes, we pulled them out, that's knowledge to which the Drakes took no action against my client whatsoever to say that you are wrong. However, they must have thought he was absolutely wrong, or they wouldn't have pulled the stakes and continued to plow. Now, in regard to the driveway, Your Honor, you can see where the driveway is. He says he put a 5-foot culvert in regard to that. Mr. Lovinger seems to indicate that our argument is about, we just mowed all this other grass. No, we used all the other grass. No, we did stuff on it. We planted garden. We took care of it. We protected it. We took care of it. We mowed it. We gardened on it. We treated it as our own. We put our vehicles on it. I don't know what you can do more with a piece of vacant land. This wasn't a garage. It wasn't a house. It wasn't another shed out there they were putting stuff into. This was vacant land that is surrounded by my client's property. So knowledge is the key here, Judge. And I read as the last thing, where the law indicates in DeGroot versus Barber, 198, Mishap 48. By contrast, where a person possesses land of another, intending to hold a particular recognizable boundary regardless of the true boundary, which is the key here. The possession is hostile and adverse and may be established. So it doesn't matter where the true boundary is. It's where my client now, in fact, is treating as his own, whatever that might be. Does he know where that line is on the east and the north and that? No, Judge, he doesn't know, other than he knows by looking at it. Can he tell you that in fact it is X amount of feet and inches to here? No, he can show you on a piece of paper, as we did with photographs of his property, photographs of the adjacent property, showing what transpired and who treated it with what. That's how he can show. Does he know exactly? No. When he walked that off with the surveyors, he showed them, this is what I have always treated as mine. That's where the occupied dwelling or occupied possession came from on their drawings. That he walked with those two other gentlemen and showed them exactly what he occupied. Not just his deeded, but the whole piece of property that was around there. It was represented to him, that he took care of, that he treated as his own, to the detriment of them, the Drakes. And that's evident by the staking, by the telling to get off when they confront each other, both he with Mr. Drake and he with Mr. Drake's daughter, and by putting the culvert in. I don't know what more you can do to say, mine, this is mine. I'm going to use it as I see fit. With that, Judge, I leave it in your sound discretion.
All right, thank you very much. I am going to take the matter under advisement, and I will issue a written decision. Thank you.
Okay, thank you, Your Honor.
Okay.